That will call the first case on the docket, 102-598, Thoroughbred Associates LLC et al. Versus Kansas City Royalty Company LLC et al.
May it please the court, counsel. Again, I'm Jeff Kennedy, arguing for the appellants in this petition for review. I would like to reserve 5 minutes, Your Honor, if I may.
That's fine. Thank you, Mr. Kennedy.
There are many issues in this case, as you all have seen from the briefing, but it's obvious that there is one that is the paramount issue and the one that the court appears to be the most interested in, and that can be framed, I believe, as whether or not the circumstances, the facts, and the law would allow this court to rewrite the Oxy lease. You really have to go back to...
Good. Counselor, can I get you to a more fundamental issue here?
Sure.
And that's one of standing. You represent the lessee here, correct?
Correct.
And the lessee is the one that filed the declaration of unitization.
That is right.
And so the lessee brought an action to have the court declare that the lessee had breached the oil and gas lease.
That would be one way to put it, Your Honor.
Well, what's wrong with that characterization?
There's nothing wrong with the characterization.
Then the relief requested is a rescission of the contract based on Thoroughbred's breach.
We're not asking to rescind any contracts. What we're asking the court to do is interpret the Oxy lease as it was written by Oxy's attorney.
Well, I understand what you're asking, but what standing does a person have to bring a declaratory judgment action to ask to find that the petitioner breached when the other party goes, no, we're not complaining about a breach? I'm having a little trouble. What standing you have to when no one else is complaining? Why do you have standing to bring that action?
Because I believe every party to a contract has an obligation to see that that contract is enforced according to its terms. And fundamentally, Your Honor, once Mr. Patton realized, as a result of a review of the lease following a request for information from Kansas City Royalty, realized that Oxy had created this extremely restrictive condition to placing that use in the unit, he really had no option but to first try to get Kansas City Royalty to agree to be part of the unit, which they refused, and then filed the action to essentially declare what the party's rights were pursuant to the oil and gas lease.
And was the Oxy lease, did it contain a different fractional royalty than the other leases in the unit?
Not to my knowledge, Your Honor.
So bottom line is, Thoroughbred as lessee is going to owe 1/8 of the minerals or whatever the fractional interest is to the landowners, whether there's 10 or 2 million.
Yes, and as I stand here, Your Honor, and I should know this, but this case has gone on for quite a long time. I can't remember whether the landowner's royalty was 1/8 or 3/16.
Well, my question is, what skin do they have in the game if they have to pay the same royalty, no matter whether there's 10 in the unit or 2 million?
Because the skin that the lessee has in this game is that it made a contract with Oxy believing that it had the contractual right to form the unit and put the lease in the unit, when in fact it did not. And part of the issue here is that the other mineral owners in the unit, including members of the Ritzke family, are distressed that they're sharing royalties with a party that shouldn't have been in the unit in the first place.
But why is that Thoroughbred's cause of action on a declaratory judgment?
Well,
why isn't that the other? I mean, I can understand Oxy going, "Hey, you unitized this contrary to the contract." They didn't. The other landowners, I mean, this isn't an action by the other landowners saying, "Thoroughbred, you're shorting us our royalties."
It is not an action on that basis, Your Honor, but that is certainly one of the factual underpinnings to the beginnings of this lawsuit. And the other thing that I think the court needs to recall is that the lawsuit that was decided in Comanche County was initiated by Thoroughbred and the others only after Kansas City Royalty had sued them in federal court, and that case was ultimately dismissed for a failure to join indispensable parties. So I think I understand where you're coming from, Your Honor, on the standing issue, but we felt like it was our obligation, Thoroughbred's obligation, to make things right vis-a-vis whether or not this unit had been properly formed.
But Thoroughbred's not the only party in this group.
No, all of the appellants consist of the working interest owners in the oil and gas lease and in the unit, Your Honor.
And what standing does my neighbor have to sue me about my contract with the oil company?
I would think that when you are...
I mean, I understand that there's money in the game there because they get a bigger share of the pot if they can kick out one of the landowners in the unit. But what we have is an action to construe a contract here, do we not?
Absolutely.
And what, I mean, on just basic flat standing on what's sitting here, not what may happen down the road, what standing does my neighbor have to sue me for my contract with the oil company?
I'm not sure that your neighbor has standing to sue you, Your Honor, but I don't think that's the situation we have here. The situation we have here is that you have a group of parties who are working interest owners in oil and gas leases who formed a 640-acre gas unit, but determined at a later point after the declaration of unit was formed that the unit had been invalid from the get-go.
And how many of those were a party to the contract that's in issue?
The only initial party to the contract at issue was Oxy, which owned a third of the minerals in a 120-acre tract that was placed into the unit. Any other questions, Your Honor? Let me go back then to the issue that really initiated this whole controversy. The trial court initially, the first round of summary judgment briefing, found this oil and gas lease to be ambiguous. That was absolutely wrong. This oil and gas lease is unambiguous, it's clear on its face, and it has a very restrictive conditional requirement for unitization. As a result of the trial court's determination that the lease was ambiguous, we then were forced to find out what the parole evidence was regarding the entry of this lease and the formation of the unit. And what we found is that the Oxy lease, which was unique among all of the leases that were put in this unit, it was unique in that Oxy did not want to have Mr. Hambright, the landman, provide them and I hate this word, but I'll use it anyway, a standard Kansas oil and gas lease. Oxy wanted to draft its own lease. Mr. Flynn, and this is covered in the summary judgment briefing that you have in the record, Mr. Flynn was extremely experienced. He had been doing this for a long time. He knew what he was trying to accomplish. He knew the law. He knew what was required in Kansas. Yet he's the party that drafted the lease that is in question here. And if you go back to the cases that are cited in your order on reformation for mutual mistake, and I understand that's something the court wants to hear about today. If you go back and look at those cases, Mr. Flynn's situation is totally different than the situations that you find in any of these 5 cases, particularly the 3 cases that deal with oil and gas issues. In those cases, you had unsophisticated, inexperienced individuals who were making judgments about what an oil and gas lease did or didn't do. You don't have that with Mr. Flynn. You have a totally different set of facts.
But what about the underlying evidence? I mean, once you're in the land of outside the 4 corners of the document, there is partial performance that would be persuasive about the intent of the parties, whether that was captured or not?
There is no question, Your Honor, that at the time that the unit was formed, the idea was that oil and gas leases would be obtained that could allow the formation of a 640-acre gas unit. And for a period of time, there was performance, and money was paid to Oxy, and money was paid to Kansas City Royalty. But that doesn't vitiate the notion that even if you have this performance, if you, and this is Hornbook oil and gas law, if you form a unit using your oil and gas leases and you don't have the ability to form that unit in the first instance, and we believe that's absolutely true with the Oxy lease, the unit is of no force and effect, at least as to the lease that couldn't be placed in the unit. And so I understand the partial performance issue, but again, it was a recognition that we had been given an oil and gas lease that didn't allow unitization under these circumstances. Again, Your Honors, if you look at the cases that you cite and you try to compare those cases to the facts of this case, it's a very, very different circumstance. And I understand, particularly the Rosenbaum case, the Texas Energies case. And that case has always been of particular interest to me because I know some of the people. I'm from Pratt. And those people made decisions. Darlene Butts, the landman, who candidly admitted that she didn't know what she was talking about when she gave the Rosenbaums, or the Hillards rather, information about the effect of the unit clauses in these leases. That's a very, very different circumstance than a situation where you've got Mr. Flynn, who knew exactly what he was doing, but didn't accomplish ultimately what apparently he wanted to do. And ultimately, Your Honors, I think this case comes down to whether or not this court is going to enforce contracts as they are written. In this case,
as written or what enforced as they were intended?
Well, again, Your Honor, I understand why reformation is appropriate to protect people who don't know what they're doing. I totally disagree that reformation is appropriate when you've got a situation where, in this case, Oxy, who has enormous resources, enormous expertise, unilaterally says, this is the lease that we're going to give you. This is all you get. And they didn't accomplish, apparently, what Flynn wanted to accomplish. And I don't think the law should protect them, Your Honor.
I understand that, but I just want to be crystal clear. It's your position, or you acknowledge, that at the time the oil and gas lease was executed, it was the intention of both the lessor and the lessee that the land that was the subject of that lease would be placed as part of the unit.
Absolutely, Your Honor, and I don't think anybody could stand here with a straight face. And going back to Justice Byers' question about performance, the unit declaration was recorded. Everybody thought that they had oil and gas leases that allowed the formation of this unit, but in fact we didn't, and that's why we tried to correct the record and why we're here today. The only other thing I want to...
Counsel,
yes.
If that's the case, I mean, that seems to be the admission that the Court of Appeals thought they got during oral argument, from which the springboard reformation of the contract decision went. So what's wrong with what the Court of Appeals did?
Well, there are several things wrong with it. Number one, they're rewriting an unambiguous lease based on parole evidence, which I don't think the law allows. That's the first thing that's wrong with it.
You disagree with the Court of Appeals' position that if there is mutual mistake, you can reform a contract.
I don't disagree that there are circumstances out there that allow reformation due to mutual mistake of either fact or law. But I don't think they apply here, Your Honor. That's the distinction.
And the reason they don't apply is because of the sophisticated nature of the parties.
Absolutely. Okay. Absolutely.
Do you think that there's any requirement on the party that's getting the benefit of the reformation based on mutual mistake to have actually asked the district court to reform the contract and to have gotten from the district court the necessary factual findings upon which to base reformation?
In this case, Your Honor, I don't think it was essential, because the notion here is that if you've got a unit that was improperly formed, you've got to fix that. I mean, that is Hornbook law. And that's the reason that we're here today. There are certainly situations where a party could come forward and say, hey, this isn't what I bargained for, and if the other party agrees, they make it right. We tried to make it right, but Kansas City Royalty disagreed with that approach.
Isn't one of the ways to fix the problem with unitization to reform the contract, as the Court of Appeals did?
It's what they did. It's what they did, and they did it without anybody ever having raised that issue, Your Honor. That's
what I was asking. But what I understand you to say is that it's so important that the unit be proper that ought to be the driving force, and not, for example, sort of lawyering 101, which is that you ask the district court to do it, and the district court makes factual findings rather than the appellate court that allows you to give the relief that's been ordered.
I would have more comfort with what the Court of Appeals did if mutual mistake was anything that anybody had ever briefed or argued or talked about. It's something the Court of Appeals latched onto sua sponte to decide the case. And I don't think the law allows that, Your Honor.
Any further presentation, counsel? I see you're out of time.
Not at this time, Your Honor. Thank you.
Any further questions? Yes.
You keep talking about a unit that's not properly formed. Why was this not properly formed, other than the fact that Oxy put the wrong language in the lease?
That's the only problem with it, Your Honor.
So with respect to KCC rules and the spacing and all of that sort of thing, if there hadn't been a mess up with the scrivener of the Oxy lease, this would be a properly formed unit.
Well, let me answer your question this way. If we had unit clauses like all of the other leases that were granted that make up the unit, absolutely. Yep. But Oxy chose to use this particular lease.
So it's improperly formed only because of a matter of contractual terms.
Correct, but I think that's true of any collective situation like this, Your Honor.
Any further questions of counsel? Thank you, counsel.
May it please the court. I'm William Skepnick, and I represent the appellees, Kansas City Royalty et al. In this appeal. picking up on Justice Johnson's last question about the proper formation of the unit, the lease in question does not prohibit its inclusion in a unit. The lease in question simply doesn't. It's ambiguous as to whether or not the lease in question permits inclusion or permits the lessee to compel inclusion in the unit. Now, in the case below, Kansas City Royalty, the whole problem started when Kansas City Royalty became concerned that the lessee, Thoroughbred, was draining the unit from an adjoining unit in which Thoroughbred was also the operator. And I know that the court has, in the first part of this argument, focused on the petition for review that was filed by Thoroughbred, but we filed a petition for review also, which we hoped was interesting to the court, and it may not be, but our petition for review is granted, and that petition for review raises significantly the issue of whether or not, because of the common operator relationship, because Thoroughbred was operating both units at the same time, whether under Kansas law and also oil and gas law generally across the country, whether there was a heightened duty for Thoroughbred as the common operator. And I just want to make this clear to the court. Thoroughbred operates the Bird unit and it operates the Retsky unit. The Bird unit, in the Bird unit, Thoroughbred has 100 cents or $100 out of every $100. In other words, every $100 produced out of the Bird unit, $100 goes into Thoroughbred's pocket. On the Retsky unit, because of Kansas City, or Oxy, then Kansas City's position in the unit, Thoroughbred takes $93.75 out of every $100. The other $6.25 going to Kansas City Royalty. So what happened was that Thoroughbred was operating the well in the Bird unit that was draining the Retsky unit, and KC Royalty had the temerity to complain about that. And in response, what happens is Thoroughbred then just says, oh, well, we've discovered that you're not even properly in the unit, so you can't complain. So they self-helped and just shut off payments under the unitization agreement to KC Royalty, and that caused KC Royalty to file a lawsuit in federal court in Kansas against Thoroughbred.
Do you agree that there was an actual controversy between Thoroughbred and Kansas City Royalty when Thoroughbred filed the state district court lawsuit?
When Thoroughbred filed the state district court lawsuit against Kansas City, we do not think that Thoroughbred had a claim against Kansas City. They, as the court,
a claim or an actual controversy?
I don't believe that there was an actual controversy because, as I believe, as Justice Johnson has appropriately pointed out, I don't think they had standing to claim that there was any breach by Kansas City of any contract.
Did you make that claim?
Your Honor, we in response to I'd have to look back at our answer. It's 11 years ago now, but
I guess you didn't make the claim, or you did make the claim, but you didn't pursue it. The district court didn't find a lack of standing.
What the district court...
And you haven't appealed the lack of...
Well, we didn't characterize it as that, Your Honor. What we said was that they had no basis to make a claim for reformation under equitable rules in Kansas. They filed a petition in equity asking for reformation of the contract and we said no. The contract appropriately sets forth the agreement between the parties, and the court should deny the equitable request of Thoroughbred. And that was our position.
Thoroughbred sought reformation?
Thoroughbred sought reformation.
In the district court?
Yes, Your Honor. Thoroughbred's original petition sought reformation of the unitization agreement based upon the lack of authority, as it put it, in the lease to form the unit. We responded that the unit, the declaration of unitization that had been made by Thoroughbred did reflect the agreement between the parties. And frankly, Your Honor, what happened at the district court was that Judge Hampton had an early hearing on a motion for summary judgment, and he didn't. Thoroughbred, or Kansas City, has never refused to acknowledge that the unit was proper and that they were properly in the unit. I mean, that was the very basis of Kansas City's lawsuit in federal court. That was the basis of our counterclaim in state district court. Mr. Kennedy has said Kansas City refused, and we never did refuse.
Do you have the contractual right to consent or to unilaterally say we're going to construe this according to intent instead of as written? You understand my question?
Yeah, I think I do, Your Honor. Let's see if I can answer it this way. Your Honor, we will agree that the lease as drafted is at least ambiguous as to whether it gives the lessee the power to create a unit. That's the issue. Because under Kansas law...
But where do you read in there that it gives lessor the right to consent even though the conditions preceding are not met?
Because there's nothing in the contract that prohibits the inclusion of the lease in the unit. Even if take the hypothetical that even if Kansas City owns 120 acres, an undivided 1/3 interest in 120 acres. Let's say it's not leased. Thoroughbred can still, and to drill a gas unit under Kansas spacing rules takes 640 acres. They actually, and we have
vertical drilling?
Excuse me, Your Honor?
Vertical drilling.
Yeah. Well, and actually I've got a copy of the map here. It's part of the record, but they sort of gerrymandered a 640 to come up with a weird shape, and we're the necessary 120 it takes to get to the 640. No question that was the intent of all the parties, was to create this 640 unit to enable it to happen. And there's nothing in if Kansas City had not given them a lease, or Oxy at that time, had not given Thoroughbred a lease, Thoroughbred could still propose a well. Thoroughbred could still have come to Kansas City and asked Kansas City to, or at that time Oxy, to include its 120 acres in the unit. That's all that the Declaration of Unitization was. The Declaration of Unitization fulfilled the actual agreement. It was central to the agreement of the parties. But even if there hadn't been an agreement already that that's what they would do, if they had come and with unleased, Kansas City or Oxy could have participated in that unit with unleased acreage. So there's nothing in the lease that prohibits that. And in fact, Your Honor, I believe that under Kansas law, if Thoroughbred at that point in time had declared the unit and Kansas City had refused to participate in the unit, I think under Kansas law, Thoroughbred could have filed an action to reform the lease and give it the power to force Kansas City into the unit. I think that's what these cases clearly stand for. Now, when Judge Hampton initially considered Thoroughbred's motion for summary judgment, Judge Hampton decided that there was an ambiguity based upon the conduct of the parties. That's what he says in his order, based upon the conduct of the parties. He says 4 years of operation. They propose the well, the consent is made, division orders get signed, Oxy's in the well, Kansas City buys the property, already participating in the unit based upon that fact. And now after 4 years of operation and payment, because Kansas City has the temerity to question a drainage issue, all of a sudden they come up with a pretext to kick them out of the well.
Doesn't the ambiguity of a contract, the launching pad for that determination, have to be the language of the contract and not the actions of the party?
Your Honor, as I interpret...
And my point is, I don't see the district court looking at the language of the contract by itself and saying, ooh, this is ambiguous.
Your Honor, and as I understand these cases that the court has asked us to focus on, and the case law generally concerning reformation, we're sort of conflating.
But I'm not asking about reformation. I'm asking about ambiguity. And isn't the very first step that any court has to do when handed a contract and has to decide whether it's ambiguous or not is it doesn't do anything other than read the language.
I'm trying to get to that. I think that we're conflating two different principles. One is the court's construction of an ambiguous agreement, looking within the agreement and finding an ambiguity, and then construing the agreement and going outside the contract to properly construe the agreement. In Reformation law, the contract can be very clear, and in fact it frequently is for Reformation. The contract is absolutely clear. But the court and the law is that if that contract does not accurately reflect the agreement, the real agreement between the parties, then the court in equity can come in and reform the contract to express the real agreement between the parties.
And you never asked for that, and the district court never found that the contract should be reformed.
Well,
did it?
We never asked for reformation because we're kind of getting confused, I think, between two different contracts. I think one of the problems here is that I think the Court of Appeals appropriately construed Kansas law and appropriately applied Kansas law, but I actually think, and this was my first reaction when I saw the opinion, I think they went around the barn to get in the front door when they could have gone straight in. I mean, I think the only problem with the decision of the Court of Appeals is that, Thoroughbred asked for equity and opened up the door to look outside the contract. That's what happened. And the Court of Appeals looked outside the contract and decided that the best way to approach it was to reconcile the lease with the unitization agreement, because the unitization agreement is what they're trying to reform here, what Thoroughbred tried to reform. I think the easiest solution is simply to deny the Thoroughbred's request for reformation, and I think that's what Judge Hampton did. I mean, Judge Hampton, in his order granting us summary judgment on this reformation question, simply adopted our brief, and in our brief we said that that Thoroughbred should not have reformation because there was no basis to reform the agreement.
Then you would agree that the Court of Appeals engaged in appellate fact-finding in order to take the route that it did, which is a route you didn't even ask for.
No, Your Honor, I don't. What I'm saying is I think what the Court of Appeals did is a way to get there. It's sort of Occam's razor. I think that the simplest is often the best. I think they could have gotten there more simply, but I think they did exactly what they were requested to do. They looked at the agreement between the parties and acted in equity and made an equitable decision.
Is there any factual dispute that at the point that the contract was made that both parties intended this land to go into this unit?
It's stipulated, Your Honor. That's not. I mean, not only is there no factual dispute, that's the only evidence.
Now you keep
without any condition.
No, without conditions. There is no the agreement. All of the testimony is that the only way that Oxy ever would have given this lease was to be included in this unit. The purpose of the lease was to be included in this unit. So
I don't see anywhere in the record, and it seems to have been controverted by Thoroughbred, that Thoroughbred's intention was to be in a unit.
That's the
I realize the lawyers are talking about it, but when you look at the motion for summary judgment and the controverted facts back and forth, no one ever just comes right out and says that it was the intent of the parties to have a unit and to. I mean, part of the frustration here, I think, is frankly, is a little bit of the lawyering on this, but. I just don't see that in the record. I mean, I've got two summary judgment motions or multiple. I set them up side by side, and I never find an uncontroverted fact that both parties wanted to play a certain way.
And, Your Honor, where you'd find that would be in the summary judgment motion from the Oxy side. We have the affidavit of Mr. Flynn and the deposition
I
of Mr.
understand
Flynn.
that. And that's what the Court of Appeals quoted, but it doesn't quote the Thoroughbred side
And
of the thing.
then on the Thoroughbred side, the court should remember that there were two motions for summary judgment, an early motion for summary judgment that was filed by Thoroughbred before any discovery had been done. And remember, KC Royalty comes in as really a stranger to the actual negotiations between Thoroughbred and Oxy. So we came in and we had to do some discovery, and we got the affidavit of Mr. Flynn, and then we took his deposition. Court denied that initial motion for summary judgment on equitable grounds because he found that there was an inconsistency between the lease provision and the conduct of the parties. Then after we did some discovery, both sides filed motions for summary judgment. And that's one in which we use the Flynn affidavit. Thereafter, after an aborted attempt by Thoroughbred to have an interlocutory appeal, we came back down, tried the case in front of Judge Hampton, and I believe in the trial transcript of that case, the Thoroughbred, Mr. Patton, who was the head of Thoroughbred, president, I think, testified that was the purpose of the lease was to.
But that was after the summary judgment motions, and that's during a trial on.
I'm just trying to tell
on your counterclaim. So you're telling us to go back and look at the trial transcript on a different claim and find a fact that we can then use in summary judgment to prevail for your party.
Well, Your Honor, first of all, I think that the testimony of Mr. Flynn by itself is sufficient to prove the intent of the parties, especially since since Thoroughbred never disputed that. I mean, Thoroughbred's briefing admitted it. Everybody knew that was the intent of the parties. So I think the summary judgment record is sufficient. But
here's what Thoroughbred said on your statement about Mr. Flynn. Plaintiffs controvert the notion that the intent that he's testified to as to Kansas City Royalty was evidenced in the language Oxy, through its attorney and agent, Mr. Flynn, chose to place in the lease. And so it seems to me that fact is controverted.
No, Your Honor.
And then in another paragraph in the summary judgment, they say it's controverted as to what Mr. Flynn says because he's not test competent, Mr. Flynn, competent to testify as to what Thoroughbred's intent was. So why don't we have a controverted material fact?
They never controverted it, Your Honor. They never controverted that the intention of the parties was to create the unit. There is that the lease was intended to give Thoroughbred the power to unitize. It is agreed that the lease was wrong in that regard because it didn't give Thoroughbred the power to unitize. Unilaterally. Right.
You're still arguing that it didn't preclude a consensual unitization.
I meant the power to force a unit, because the court may be aware there are some states like Oklahoma in which you can force a unit and force pool, but Kansas doesn't permit that.
Mr. Skepnick, I need you to clear something up for me. I heard something that I thought might be a contradiction in what you've said through the whole argument. At one point you said that this lease wasn't necessary.
No.
The lease wasn't necessary.
Yes, Your Honor, I did.
You said that. But then you also said your client wouldn't have entered into it but for its desire to be part of the unit. And I'm confused by those two statements. Maybe there's not an inconsistency there, but it sounded like one to me.
And I'll explain that, Your Honor.
That'd be great. Thank you.
Thoroughbred had to get Kansas City's consent to join the unit. Now, that consent could be given by the lease, or that consent could be given other ways. When Thoroughbred declares the unit and Kansas City agrees to go into the unit, Kansas City then consents. I mean, you could say offer and acceptance, that's contract right there.
So the answer to my question is who we're talking about, which side of the bargain.
Now you've lost me, Your Honor.
Well, who needs to consent and who can force
Well,
them to do what?
it would be Kansas City that needs to consent because
Right.
the
Okay.
offerer would be Thoroughbred and the
What you're saying is the vehicle to make that consent can either be in the lease or outside the lease.
Yes.
So the lease wasn't necessary, but the consent was.
Yes, Your Honor, and that's my weird argument, I guess, about around the barn. I don't think the Court of Appeals needed to make that determination.
Can I clarify? You kept talking about reformation, that Thoroughbred was asking for reformation. That was reformation of the unitization declaration.
Yes, Your Honor.
Okay. Real quickly, on Skelly Oil, why isn't that different than our scenario here? Because the liquid hydrocarbons are intertwined in the gas stream, whereas the oil isn't. You understand what I'm saying? You have to do a process to extract the liquid hydrocarbons. The oil is separate when it comes out of the well.
If the court will permit just a short answer to that, because that's another issue that we haven't talked about so far. The lease does not distinguish between oil and gas. It's all hydrocarbons were leased, and that's what when the unit was declared, it was declared as a gas unit because that affects the spacing. There's nothing in any of the record that suggests that there was an agreement to separate the oil from the gas and treat it differently. In this, and the Skelly case, is it right? The Skelly case stands for the proposition that incidental gas or incidental oil to the other production becomes a part of the same thing. There's nothing in the record that would support this theory that has developed. Nothing at the trial court level, nothing before the Court of Appeals that has developed as part of the petition for review that this court needs to, or that this case should be a basis for this court to distinguish between oil and gas. On the facts in this record and the facts here, there's no basis for doing it. And actually, we supplied the court with supplemental materials a few weeks ago. To sort of clarify that point, we think it would really be bad law for this court to change the law as it is on that point.
Do we have any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
I understand you reserve 5 minutes for rebuttal.
Thank you, Your Honor.
Mr. King, before you get underway, I have 3 questions.
Okay.
So let's just concentrate on the first one. It's just a procedural history question. I think I saw you and your partner shake your heads or react in some way when your opposing counsel indicated that Thoroughbred sought reformation in its petition.
Totally wrong.
Okay.
We never sought reformation of the Oxy lease. And ultimately, that's what the Court of Appeals did, and that's why I have problems with what they did.
That's what I clarified. The reformation was reformation of the unitization declaration. Did you ever seek to reform the unit?
For the reasons that I articulated earlier, Your Honor, because a unit using oil and gas language that doesn't allow unitization, as we have here with the Oxy lease, it's void ab initio. So we had to amend the declaration of unit. But
Okay, that brings me to my second question.
okay,
Your opposing counsel took the position, of course, that the lease was unnecessary, that consent can be determined otherwise. And maybe this just goes back to the original question from my colleague, Justice Johnson. But if that's true, first of all, do you agree that's true? And if it is true, then why does the condition in the lease queer this entire deal as a matter of law?
because the lease that Oxy gave us, the only lease that they would allow to be applied to the minerals that they owned, precludes unitization because the conditions
not
don't
being
exist.
met, right? And that was their position at that time.
Correct.
But time marches on.
Time marches on, Your Honor.
And since then, there's been all of this other behavior consistent with there having been a consent with or without a lease. That's the problem I think that my colleague was trying to get to at the very beginning.
I don't think there's ever a consent unless there is something above and beyond the oil and gas lease.
It's
and
not a consent to accept payments?
There could,
Isn't it a consent of sorts to accept payments consistent with the party's previous view? Whether it's been memorialized in
I
the
think
written
there's
agreement or
law
not?
to that effect, Your Honor.
That there could have been an oral
But,
okay, that's
but
my second
that
question.
that doesn't resolve the problem with the lease itself.
And then let's go to that. That brings us
Okay.
to my third question, and that is this: what is your response to your opponent's argument that there are legions of cases having to do where reformation has been allowed or at least considered, where the contract's clear as a bell? Because when you're talking about reformation, you're in equity, and it's about equity. It's not about clarity of contract.
I have yet to find a reformation case where the contract was clear as a bell.
Okay. So you just disagree with his?
I disagree with that completely.
Okay.
And I think I'm going to give this court great deference, as I should. You cited 5 cases on mutual mistake that you think are important to this appeal. None of those cases are anywhere close to this case. They're very different cases.
Is there, on the ambiguity, back to the ambiguity,
Yes.
I understand you to say it's unambiguous that Thoroughbred could not force the unitization of this land unless certain conditions were there and they didn't exist.
You either had to have the conditions, which didn't exist, or you had to have some ancillary consent to the unitization.
Okay, so that's it. The contract itself did not unambiguously prohibit a consensual unitization.
Oxy or Kansas City Royalty could have always made a later contract.
Well,
but
is
didn't.
the answer to that yes? That there's nothing in the contract that precludes a consensual unitization of this land.
I think I disagree with that, Your Honor, because the language in the contract doesn't allow Thoroughbred to create the unit that it created.
No, I'm saying that allows the lessor to consent. Is there anything in the contract that precludes the lessor from entering into a consensual unitization agreement?
We asked them to consent, Your Honor.
No, is there anything in the contract that unambiguously precludes that?
No, just as there's nothing that gives Thoroughbred the unilateral right to form the unit as it did. One other thing. We talked a little bit about the oil and whether or not this unit declaration encompassed the oil. One of the many problems with the trial court is that, ignoring the ambiguity issue and everything else, when it decided the interpretation of the Oxy lease, it also decided everything else in favor of Kansas City Royalty. There is nothing in the record that talks about whether or not these liquid hydrocarbons, using your phraseology, were intertwined with the gas. I defy you to find that in the record because it doesn't exist. And it's just one example of the many errors that the trial court made in its disposition of this case. I see I'm out of time.
Do we have any further questions of counsel? I see none. Thank you, counsel.
Thank you.
Thank you all for your arguments this morning. Court will take this matter under advisement.